What are the privacy rules for reporting elder financial exploitation? Imagine discovering that an elder you know might be losing their money to someone they trust. What should you do next? Reporting suspected financial exploitation is a delicate process that balances protecting the elder's privacy with the need to act quickly. First, certain professionals like bank employees, doctors, social workers, and caregivers are legally required to report any suspicion of elder financial abuse. They can share relevant details with authorities without breaking privacy laws. These mandated reporters are protected when they disclose such information in good faith. Federal laws, like the Gramm-Leach-Bliley Act, generally protect financial information, but they also include exceptions. These allow financial institutions and their staff to report suspected abuse to law enforcement or adult protective services without violating privacy rules. This means they can share enough details to help stop the abuse while still keeping the elder's information confidential. When a report is made, it is usually kept secret. The agencies receiving the report often use secure methods, like confidential online forms or sealed documents, to protect the elder's privacy. The identity of the person making the report is also often kept confidential, depending on state laws. This helps prevent retaliation or further harm to the elder. Timing is important. Mandated reporters are typically required to report suspicions immediately or within a very short period, often by phone first, then followed by a written report. Some states requiring reporting to both law enforcement and adult protective services, especially if the elder is in a long-term care facility. If a person with power of attorney is suspected of financial abuse, reporters can sometimes bypass the authority of that person and alert authorities directly. This is especially true if the elder's assets are at risk or being misused. It's important to remember that each state has its own rules. Some states have specific forms, reporting timelines, and designated professionals who must report. Financial institutions usually have policies aligned with both federal and state laws to ensure they follow the rules. In elder law and estate planning, understanding these privacy rules is key. Reporting quickly can prevent further financial loss. Legal professionals advising elders should know their reporting duties and confidentiality protections. When creating powers of attorney, trusts, or wills, it's wise to include safeguards against exploitation and clear procedures for reporting concerns. Working closely with adult protective services, law enforcement, and financial institutions helps protect elders' money and privacy at the same time. These rules are designed to allow necessary action while respecting the elder's rights. In the end, the goal is to stop financial exploitation fast and keep the elder safe and secure.